Okay, so let's move into this topic of the Digital Millennium Copyright Act and virtual worlds. And we're talking about the Digital Millennium Copyright Act here. There are a number of pieces of the DMCA, and as we have seen, we've spent a fair amount of time looking at cases involving the notice and takedown provisions and red flag knowledge and so on under the DMCA. So that's kind of one portion of the DMCA. Another portion of the DMCA relates to technologies that protect access to a copyrighted work. Really, I think the design or the intent or understanding when this was passed was to protect encryption that protects access to a work. So think about a DVD or a Blu-ray that you might have. If you drop that thing into your computer and try and burn a copy of it, you can't just do that. It's protected by encryption. Whatever software you're trying to use to burn a copy will not be able to get at the underlying code and decipher it and burn you a copy. The only way you could do it is if you have a piece of software that cracks the encryption. Now, this is actually not that hard to do, certainly not with the kind of encryption that protects DVDs. Some kinds of encryption schemes are harder to break, some are less hard to break. But what this part of the DMCA does is it says that cracking or breaking that kind of protection measure can itself be an offense. Now, this is not an offense under the Copyright Act. It's under the DMCA, which is really, if it's examined, I suppose, passed under the Commerce Clause, not under the Intellectual Property Clause of the competition, but nevertheless a federal statute. And then there's another piece of the statute that talks about trafficking in the technology, in other words, distributing technology that allows this kind of encryption to be broken. So the classic case is DRM, digital rights management, some kind of encryption scheme on something like a DVD, and a program that when you drop that DVD in your computer and want to burn a copy, this program allows that encryption to be bypassed or broken, and you can burn a copy of the program. That's the classic case. In virtual worlds or video game worlds, it can be a very interesting thing, because if you think about some of these games, and the case we have to look at is a Ninth Circuit case involving the game World of Warcraft. Some of these are persistent, massive multiplayer games. And as you're playing the game, you're building up the levels of your character. Your character's getting stronger, your character's getting more treasure, more weapons, more power, and is able to do more and more as you advance through the game. So the early stages of the game, you have a character that is not very powerful, that can be killed very easily, and it's hard to kind of take the time to level up and get to that level where you have a higher performing character. Well, one of the ways that you can do this, and there's actually a market for this, you can hire someone to play the game for you and get through those early levels. That's one way people do it. But another way people do it, is they buy characters. So people will play the characters, level up, and then sell their passwords and so on in an online forum, so you can buy the character. Another way is you can use a bot. So you can actually use a piece of software that will go online for you while you are not personally online, and automates the playing of the game and automates the leveling up of the characters. And this is what this glider software did in the World of Warcraft game. So as the quote from the case here indicates, you kind of tell glider what to do, and then it will automatically do it and allow you to level up. Now, obviously, the creators of the game don't want you to be able to do this for a whole bunch of reasons. One is, it affects the integrity of the world, the integrity of the game. The notion is you're supposed to be able to kind of level up and advance in the game as you get better at it. It's kind of a reward for getting better, and so the idea is this affects the whole integrity of the game. Some of these games actually develop kind of secondary economies. So there's some degree of buying and selling of equipment and goods and the like that is legitimate within the game. Very often the games allow you to buy equipment and goods and other things as in-game app purchases, and so the manufacturer of the game is also making money through that. So there's a number of kind of gameplay related reasons, community reasons, and economic reasons why the manufacturer of the game may not want you to be able to use something like this. For those of you who haven't seen Warcraft, here's just a real brief piece of the trailer for the game. Rated T, as you see.
Drink, Hellstream. Claim your destiny. You will all be conquerors. And what, Gul'dan?
So you get a little bit of a sense there of the sorts of kind of humanoid character monsters that are going on and the things you would do.
Must we give?
So what ends up happening is Blizzard, the maker of this game, first of all has a prohibition in its terms of service against using bots. So if you are a player and you're signing up for the game, you click I agree to the terms of service and you represent you're not going to use a bot, and you can get kicked off the site if you're caught using a bot. So they have that, but they also have a technology that they're using to try and detect and eliminate the use of bots that Blizzard calls its Warden technology. So the first thing this technology does is when you log on to the game and boot up the game, it scans your computer's library of DLL, Dynamic Link Library files. These are files that allow apps and programs to communicate with each other and with the operating system on the computer, and they will have specific signatures, or they can have specific signatures relating to different kinds of programs. This is the way, for example, virus technology works. In part, it's looking for DLLs relating to viruses. So the Warden technology is scanning, looking for DLLs that are identified with bots. Now, very cleverly, the Glider program, the program at issue, the bot program at issue, is reconfigured by the maker of Glider to not load until after the DLL scan is complete, which means that the DLL scan is not going to pick up Glider through this method. The other thing that the Warden program does is it's going to scan the user's computer while it's connected to the World of Warcraft servers, and it's going to look for certain patterns of code related to known bots or cheats. So again, it's kind of like a virus scanner. This isn't a virus, right? But a virus scanner will do a similar thing where it's looking for DLLs, it's looking for certain patterns of code, it's looking for file names, other things like that. Again, if there's a match, the player is booted from the game. So what happens here? First question, is the maker of the Glider software liable kind of out of the gate for secondary copyright liability? Right now, the maker of the Glider program is not itself infringing directly on any copyright in the World of Warcraft game. It's not. They're not downloading the game. They're not making a copy of the game. They're not redistributing the game. But they are allowing the player and facilitating and encouraging the player to download and run the game, which requires a copy of the game to be made, or at least parts of the game to be made on the local computer, in a way that violates the terms of service. So is that encouragement to violate a terms of service equivalent to an encouragement to commit copyright infringement by the user, by the player? And if it is, that's potentially a contributory or vicarious copyright infringement. But the court says it's not. And it's not because, and it looks carefully at what a terms of service is. So first of all, the WoW players, the users, are not owners of the game. They're not owners of the software. They're licensees under the license. But the terms of the license that relate to bots are, the court says, contractual covenants, not contractual conditions. Why does that make a difference? If it's a contractual condition, which might be, for example, you pay a monthly fee to be able to continue to use the software. All right. So as a condition of being able to use the software at all, you pay the fee. If you don't pay the fee, you don't have a right to use the software. If somehow you're finding a way to use it anyway, you're making an unauthorized copy, that's a violation of a contractual condition. You're not protected by the license, you're infringing copyright. But a covenant is something different, and the remedy for violation of a covenant is not a copyright infringement claim, but it's a remedy relating to that covenant, whatever that remedy might be. So for the individual user, they're at best violating a contractual covenant, which means that the maker of Glider potentially could be liable maybe for something like tortious interference with contract, but can't be liable for secondary copyright liability. All right, now the court moves into the question of the DMCA. You might ask, well, wait a minute. The court has just decided there is no secondary copyright liability. This is not, and even a user using Glider is not infringing copyright. At best, they're violating the contractual terms of service. Why are we moving on to the DMCA? Doesn't the DMCA involve encryption and related technologies that protect access to a copyrighted work? That would be a very good question. And in fact, that's one of the issues that's litigated and decided here by this court in a very interesting, perhaps controversial, and I think really potentially wrong way, but nevertheless, this is the decision in a very important circuit, obviously the Ninth Circuit, involving law relating to video games. So here's what the court says. The DMCA, the part of the DMCA we're talking about, the anti-circumvention and anti-trafficking provisions, create two kinds of claims. One is circumvention of a technological measure that effectively controls access to a protected work, and a copyright owner is able to enforce that prohibition. The second is trafficking in technology that circumvents technological measures that effectively protect a right of the copyright owner. So notice that the first bullet there, circumvention, has to do with control of access. The second bullet has to do with a right of a copyright owner. The court, the Ninth Circuit, says that the anti-trafficking provision goes to the exclusive rights of copyright, whereas the anti-circumvention provision does not. In doing this, the Ninth Circuit rejects the reasoning of the Federal Circuit in different cases involving this same legal issue, where the Federal Circuit said both the circumvention and trafficking provisions require an infringement nexus. The whole structure of the DMCA only makes sense, the Federal Circuit said, if anti-circumvention relates to then breaking in and getting access to do something that would infringe copyright. The Ninth Circuit says no. The technology is protecting access to the copyrighted work. But if you break the technology and are doing something else that isn't infringing copyright, like facilitating a breach of contract, you've still broken that technology that still violates this provision, this section of the DMCA. So then the Ninth Circuit, and that's a pretty controversial, I think personally incorrect holding, but there it is in the Ninth Circuit. The court then goes down and says, all right, what exactly happened here? Does the Warden technology really effectively control access to the work or not? And so first of all, as to individual literal or non-literal elements, like a specific character if they're copyrighted, or a specific storyline, or a specific sequence of images, the court says it doesn't protect that. It is not an encryption scheme, right? It's not like the thing that doesn't allow you to copy a DVD onto your computer. So it's not doing that. But the court says, as to the dynamic non-literal elements, whatever those are, and I assume it means sort of the entire gameplay, like the feel of the gameplay, the Warden technology does, in some sense, control access to that. Again, I think this is really a problematic holding, but there it is in the Ninth Circuit, and therefore the court says, on that basis, the permanent injunction that had been entered in the court below against the glider technology can be affirmed. One other piece of this, even having reached that holding, the Ninth Circuit goes on to talk about the trafficking claim, and here the court says, no, there is no violation of the trafficking provision because the Warden technology does not prevent copyright infringement. That's not what it's about. It's about policing things that are really violations of a terms of service. So, real interesting opinion. As you can see, already a circuit split with the Federal Circuit. I don't know if this issue is important enough yet to, even with a circuit split, to get up to the Supreme Court, but I think it's a very interesting, and it will have implications as we try to continue to apply the DMCA and the circumvention provisions to video games and virtual worlds.